website for review by anyone that's interested in what goes on at a county board meeting. So with that, we'll move on to item 3. Dale Foster, our chaplain, is going to go over our invocation, and then Robert, pledge of allegiance. So would you please stand, Ms. Foster?
We will all bow our heads for a moment of silence, after which I will say amen and then give our evening prayer. A moment of silence for our servicemen and women in Afghanistan, Iraq, Pakistan, Syria, Africa, and the United States. And last but not least, for our partial government shutdown in the United States. Amen. Our dear Heavenly Father, thank you for our meeting together again this lovely fall day. We ask you to send your healing power to any of our sick, including especially Carol Hafner, our former board secretary. Send your comfort to any of the bereaved family members of our board and elected officials. Our county officials and our board are asking for you to send your comfort and our deepest sympathy to Danville's well-known mortician Bob Pape's family. Please protect our children and watch over them this Halloween season, especially trick-or-treat night. Help us to have an agreeable meeting as we make decisions for all concerned today concerning our budgets. All of these favors we ask in your name, and all of this thanks we give in thy name. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Clerk, will you go ahead with roll call, please?
Mr. Chairman, we'll begin this evening with Mr. Alexander.
Present.
Barney. Mr. Barney. Boyd.
Here.
Criswell.
Here.
Davis.
Here.
Dodge.
Present.
Greer.
Here.
Foster. Present. Fox.
Present.
Green.
Here.
Jenkins. Here. Johnson.
Here.
Knight.
Here.
Lee. Mr. Lee. Marin.
Here.
McMahon. Mr. McMahon. Miller.
Here.
Moxie.
Here.
Nesbitt.
Here.
Nightringer.
Present.
Stahl.
Here.
Stark.
Present.
Stone.
Here.
Wall.
Present.
Wright.
Here.
Chairman Weiner.
Present.
23 present, 3 absent, and 1 vacancy, Mr. Chairman.
Thank you, Madam Clerk. We have a quorum. Moving on, item 6 on our agenda is the adoption of our agenda. Are there any amendments from the floor concerning the agenda? If not, the chair would entertain a motion to approve the agenda. Mr. Alexander?
Do we need an executive?
Not to my knowledge tonight, Ms. Foster. Mr. Alexander has moved to adopt the agenda. Is there a second, please?
Second.
Ms. Foster, a second. Any discussion? If not, roll call. No, a voice vote, please, for accepting the agenda. All those in favor, please say aye.
Aye.
Opposed? Motion carries. We have item 7, the approval of the minutes. They're in your packet. I hope you've had an opportunity to read them. The chair would entertain a motion for approval. Mr. Fox has moved. Ms. Foster second for approval of the minutes. Any further discussion, additions, or corrections? If not, we'll call a voice vote. Please, in favor of adopting the minutes as presented, say aye.
Aye.
Those opposed? Motion carries. Thank you. Report on claims, that's on your desk in front of you. The chair will entertain a motion for approval of the report on claims. Mr. Alexander has moved. Is there a second, please? Mr. Griswold has moved a second. Any discussion about the report on claims? If not, roll call vote, please.
Yes. Mr. Boyd?
Yes.
Criswell?
Yes.
Davis?
Yes.
Dodge?
Yes.
Fox?
Yes.
Green?
Yes.
Jenkins? Yes. Johnson?
Yes.
Knight?
Yes.
Lee?
Yes.
Maron?
Yes.
Miller?
Yes.
Moxie?
Yes.
Nesbit?
Yes.
Lightlinger?
Yes.
Saul?
Yes.
Stark?
Yes.
Stone?
Yes.
Wall?
Yes.
Wright?
Yes.
Alexander?
Yes.
Chairman Weiner?
Yes.
24 yes, 2 absent, and 1 vacancy, Mr. Chairman.
Thank you. Report on claims, motion carries. Audience, or number 9 on our agenda tonight is audience comments. We've put these back at the beginning of the meeting tonight because of, some, InvEnergy comments later on. I would remind people that are involved in audience comments, they are limited to 5 minutes each, and a total of 30 minutes for audience comments will be allocated tonight. So with that, we're at number 9, and those that wish to come, please come forward, identify yourself, and you have 5 minutes. Need to be passed out to the board. I do that, or just step down? And who do I give this to? Okay.
Marshall Newhouse, 13407 Capron Road, Capron, Illinois. Now, wherever discussions are occurring around the state of Illinois dealing with wind turbines and setbacks for them, there are competing interests at stake. Where there are zoning codes and the county board has clear direction, the assumption is they have the county's health, safety, and general welfare as their highest priority. That does not change if there is no zoning code. Placing turbines with significant setbacks so you can protect your residents is still your responsibility. The other competing interest facing the county board is the area of finances. The promise of revenue flowing to taxing bodies generated by turbines and the rent being received by property owners is a powerful enticement for packing the turbines in as tightly as possible. Now, as you attempt to weigh these competing forces, I would like to tell you what's going around the state. You are not breaking any new ground. Multiple counties have been where you are now. The changes have been occurring throughout the last 10 years, and they are accelerating these last couple of years. Developers are still pushing for setbacks of 1,000 feet from primary structures. And depending on the density of housing in the county, they will sometimes go out as far as 3 or 3.1 times the height of the turbine from primary structures. If their spokespeople are worth their salt, they will adamantly state that anything more than that would be a project killer. That's the industry line, and it is used to throw the company's weight around. The fascinating thing is that counties are no longer in the dark about the devastating effects of turbines in close proximity to housing. Many of them have learned and are using the useful tool of waivers to shield residents who would be impacted by living in the shadow of these industrial machines. If your county is relying on the setback study developed by an Illinois grad student in 2011, you're hearing of a lot of counties with 1,000-foot setback, and you are missing today's story. I would like to tell you what your neighbors are doing to allow wind in while respecting the health, safety, and general welfare of their citizens. Some examples are Grundy County at 1,800 feet from primary structures and a 400-foot height limit. Bureau County at 3.2 times the height from primary structures. Woodford setbacks are 4 times from primary structures and a waiver of 1.1 times the height from primary structures. Now, with all the county changes highlighted, Vermilion setback at 1,200 feet from primary structures is seen as swinging the door wide open with reckless abandon. 1,000 foot was put forward by pro-wind interest 10 years ago when the turbines were no more than half the size they are now. Now, with all the changes spotlighted, Vermilion is seen as the county that knows something that everyone else doesn't know, or is missing something every other county has picked up on. I would ask you to look east, just beyond your borders, to see what your neighbors in Indiana are doing. On the second page of the handout, if you've gotten that, there's a listing on the left of every primary structure setback from the 6 counties highlighted. Within the last 2 years, they have gone to the right side of the page. These counties have understood what it means to double the size of these turbines and keep them in close proximity to housing. Let me be clear. Vermilion has every right to pursue further WEX development. In the same light, you have a huge responsibility to protect your citizens. I would like to make a recommendation to you, and I make this knowing that you do not have a zoning code. You will be sitting in the driver's seat during the special use process. The developer needs your vote, and they will have to agree to conditions hammered out in negotiations. Look around the state at setbacks that protect citizens, and understand that every setback in the state is from property lines, with the exception of those dealing with wind turbines. A citizen's property rights does not end at their doorstep, it ends at their fence line. That setback from property lines will look restrictive, and to protect those residents in your jurisdiction, it needs to be. Couple that number with a waiver to a shorter distance that will allow a developer operating room. A couple of things are going to happen if you do this. The developer will whine about this being a project killer. Well, at the same time, they're going to be knocking on doors to find out how much money it will take to convince property owners to sell out some of their health, safety, and general welfare concerns. This is not rocket science, folks. Make some calls around the state and find out what's working for your other counties. Now, most of you know machinery. The idea that machines make noise, break down, fall apart, have electrical issues, and sometimes are just plain offensive looking should not be a surprise to you.
Mr. Newhouse, your 5-minute time has expired.
Thank you, sir.
Julie Newhouse, 13407 Capron Road, Capron, Illinois. We did not comprehend the full consequences of a poorly sited project until your hearing early this year. Previously, we had listened to Mainstream, the wind developer in our county, plea to keep our setbacks at 1,000 feet, with promises to do the right thing. Then Mainstream brought Dr. David Loomis of Illinois State to testify with the same plea, because wind companies will protect homes and people's lives if there was a problem that wind companies would make it right. InvEnergy has now become the poster child for Boone County on why a county has to educate themselves and their county board in order to protect the lives and properties of their citizens. I use California Ridge as the example of how wind industry works and what low setbacks will do to a community. What's worse is the children suffer the most. I wonder how much your children will need to struggle before anyone acknowledges their decline. You can tell a great deal about a community when you see how they either protect their youth or are willing to sacrifice their children's well-being for economic gain. Today we traveled from Boone County in the middle of soybean harvesting because InvEnergy was on the agenda with an update. I'm curious, will they accept responsibility for the consequences here and be responsive? Dr. Loomis and Mainstream both promised under oath that wind companies are responsive to concerns and will make it right. But now as the county board, you are educated. You have the opportunity to make changes. You hold all the cards. You can declare a moratorium on building permits until two things happen. One, InvEnergy ceases to do harm to the neighboring property or compensates affected property owners for abandoned homes. And two, determine a safe setback policy. And only after both have occurred do you lift the moratorium and are willing to agree to building permits with industrial wind companies. Tonight I am also submitting to the board evidence from two doctors who describe the same consequences your own citizens have testified about. Also, I'm submitting the complaint form that one county uses, and maybe your county should consider as well. I do not have time to read the testimony from the Harvard Medical School graduate Dr. Reiter to the state of Vermont Senate describing his patients who live among wind turbines, but I would like to highlight Dr. William Holstein's letter to the Falmouth Board of Health. Dr. Holstein's personal experience with the turbines writes, sleep disturbance is not a trivial matter. Children with inadequate sleep perform poorly academically, emotionally, and physically. Errors in judgment and accident rates increase when inadequate sleep and fatigue for everyone. No one is exempt. In the world of medical illnesses, all of The varieties are destabilized by fatigue secondary to inadequate sleep. Diabetic blood sugars become more susceptible to fluctuations. Cardiac rhythms become irregular. Migraines erupt in increased intensity. Tissue healing is retarded, and so forth. Across the entire field of medical medicine, psychiatric problems intensify, and people lose their ability to maintain normal psychological defenses. People with no previously identified psychiatric illnesses are destabilized by sleep deprivation. Sleep deprivation experiments have repeatedly been terminated because test subjects become psychotic. Should my work key into with sleep deprivation breaks down individual defenses and mimics a broad range of physical and mental illness. Let's hope the town of Almont comes to its senses and stops abuse. He wrote this letter because he's seen way too many boards trivialize symptom reports from people living close to wind turbines. I have witnessed attempts to discredit people who are being hurt by turbines. I hope that this board does not do that. Thank you.
Thank you, Ms. Woodhouse.
Kim Shirk, Post Office Box 347, Hudson, Illinois. I'm here tonight to tell you why you're in this mess you're in, why you have a room full of people over there complaining about noise, when you had a noise study done that said there wouldn't be this problem. I'm going to tell you about 4 noise studies done in Illinois. 2 were by InvEnergy. First one was Grand Ridge in 2007. The way they faked the noise studies. First thing, they do the monitoring in January. They pick the highest wind month of the year to get a high background noise to say our turbines aren't as loud as what's out there now. January is the 3rd windiest month with 8.5 mile per hour winds. Only March and April is windier of 9. I find it ironic the 2 noise studies to get into project approved are done in January, and yet the noise study being done here now is being done in August, which is the lowest wind speed of the year, to say that their turbines are compliant. So at Grand Ridge in LaSalle County, they were able to fake the noise study by getting a reading of 85 decibels loud at 3:30 in the morning. This is unheard of in a rural county because the normal levels are 25 to 30 decibels. I went to good old MapQuest Google Earth, and I Googled the 2 locations. Now, this one looks pretty normal. If you notice the large metal shed, we have been told that that is a puppy mill. This is January. I'm assuming heaters were running. I'm assuming there were a lot of dogs barking to get that unnaturally high 85 degrees. Second location in January, notice the 2 grain bins. You've got the condensation, you've got to keep the corn dry. You can get 85 decibels by running blowers and dryers all night. So that's their justification, and then they say there's so much background noise that our turbines won't violate. It'll mask the turbine noise. Another way they fake it, it's garbage in, garbage out of the model. This is a quote from their noise study. Wind turbine noise emissions data provided by GE tested only at a 22 mile an hour wind speed. They pick their speed, they give you the data they want. When it's not 22 mile an hour, you get quieter on the ground and you have these people complaining. The next one is InvEnergy's White Oak project, which is where I live. Timothy Casey, they brought in an expert. He got him throughout the hearing to admit that he didn't actually do the noise study. He says they took noise up 2.5 miles away from the interstate so they could find a representative rural ag location. Failed to tell you that right next to that location was a pond, which is naturally reflective. East White Oak Bible Church, which has 1,000 people per week coming into their parking lot on Sunday morning. Additionally, I went to this pond and took noise readings myself. When they got, I think, 79, 80 decibels, I took about 8 readings myself, and I got in the 30 to 40 decibel range. What was the difference? I did it in March without the cattle. They did it in January. To make the noise louder, they brought in a temporary metal cattle fence. They fenced it in around the pond. They put cattle in, and we don't know how they did it, but Mr. Casey, their expert, testified that their normal way of collecting data is chaining the noise meter to a tree in someone's yard. Now you can imagine January prevailing winds, cattle, geese landing on a pond, reflective noise, 1,000 cars coming into East White Oak parking lot, and they've got a chain to a metal fence with cattle. In addition, this quiet rural background that they're telling you is representative also had a landscaping business within a quarter mile of it, running heavy equipment like skid loaders, moving rock, and loading heavy equipment. Again, the expert witness, when questioned under oath, said he didn't actually do the study. They submitted a study without him, which showed violations. They brought him in later, and he, I'm losing my place here, pardon me. He testified that he did not perform the study. He just analyzed the results, and he had actually testified at the hearing a week or two before the second set of results came in. So that's another way they fake the study. They put one study in, and then they switch it to another one. So this guy didn't even have a clue because he wasn't involved in the study.
Thank you, Mrs. Sherwood, your time is up.
Thank you. I would like to finish by saying there are two other studies in here. One is findings of fact on Arthur City Council on why they denied the permit. The last one is experience in Vermilion County when Iberdrola did the exact same thing. Thank you.
Mr. Chairman and members of the board, thank you for the opportunity to speak with you tonight. My name is Jessica Ashton Hartsey. I'm a longtime resident of Pilot Township here in Vermilion County, and I currently live in Hope. Some of you know me as Jessie Ashton, longtime 4-H and FFA member who showed livestock at the county fair with you or with your children. Some of you know me as Jess, the Sadler feed mill girl who took and filled your feed orders when you came in to get livestock feed. Some of you in this group know me as Jessie, the young girl who started at the Colliston Church as their pianist when I was 11 years old. After a few years away from home and the completion of my doctoral degree, I could have moved literally anywhere in the whole world. My husband and I could have chosen to live anywhere we wanted to. But we chose purposely to move back to Vermilion County. I wanted my children had growing up here, including the opportunity to attend the same wonderful rural elementary and high school that I attended as a child. That was the Armstrong School District. Today, I'd just like to share with you a letter from a local school superintendent. And this is addressed to Mr. Weiner. Dear Chairman Weiner, my name is Bill Mulvaney, and I am Superintendent of Schools for the Armstrong Township High School and Armstrong Ellis School District. I also served on the wind panel that met to try and give direction to the county board on wind turbine ordinances. Our panel did not come up with any recommended changes, but I would like to share a few thoughts with you. I've noticed that we have some children in our district that appear to be having medical issues related to the operation of the wind turbine. Headaches, lack of sleep, and jaw issues seem to be the most common. The students also complain about not being able to sleep or not getting a full night's sleep due to the noise issues. We have also been advised that we will be losing a couple of families in our district because of the wind turbines that were placed close to home, and the families can no longer handle the flicker and noise issues. While these issues were brought up at our panel discussions, I was not fully aware of the impact that the wind turbines would have to my school district. It is never a good thing when children have health issues or families have to leave their homes to get away from the turbines.
The revenue generated by the turbines is a blessing to our schools, but the unintended consequences are real. I hope that this letter sheds some light on real issues that affect districts that house wind farms. I also hope that when ordinances are discussed in the future, that these issues are considered. Sincerely, William T. Mulvaney, Superintendent for Armstrong Schools. Thank you.
Thank you, Mrs. Ortiz.
Hi, I'm Darrell Cameron from Rankin. I wanted to take a couple minutes to speak further on an item from last month that was discussed, pending lawsuit in Oregon in the case of Daniel Brian Williams versus InvEnergy LLC, an Illinois company. Mr. Williams is suing InvEnergy for an amount not to exceed $5 million for invasion of noise, vibration, and shadow flicker on his property. I would like to read you some excerpts from the lawsuit filed in August of this year. The plaintiff alleges that the defendant, InvEnergy, constructed and operated a wind turbine complex next door to the plaintiff's rural property in violation of and without any consideration being given to statewide noise pollution regulations, which limit the amount of noise pollution that wind complexes are allowed to generate. Plaintiff further alleges that the invasion of noise, vibration, flicker, strobe, glare, flashing red lights produced by the defendant's wind complex constitutes both an illegal nuisance and a trespass cognizable under Oregon law, causing damage to his health and homestead. Plaintiff is seeking an award of compensatory damages for emotional distress, deteriorating physical and emotional health, dizziness, inability to sleep, drowsiness, fatigue, headaches, difficulty thinking, irritation, and lethargy suffered as a result of InvEnergy's past and continuing invasion of his property. Plaintiff also seeks recompense for the cost of hiring an acoustical expert, diminution in the value of his land, legal fees expended, and litigation costs incurred. In the summer of 2008, during the construction of the wind turbine complex, plaintiff and other neighbors complained to InvEnergy about the adverse effects anticipated from the operation of the turbine complex being built so close to their homes. The InvEnergy project director assured neighbors and plaintiffs that noise from the wind turbine complex was in compliance with applicable law. In December of 2008, the InvEnergy project manager wrote to the Planning Commission asserting that its computer modeling showed that the noise standard would be met at the plaintiff and the other complaining residents' homes. This assertion later was proven by InvEnergy's own testing to be grossly false. Page 5 of the lawsuit. Page 6 of the lawsuit. In May of 2009, InvEnergy hires a wind energy consultant to set up and conduct field noise studies. By a report dated June 2009 from the consultant, it acknowledges that noise levels exceed limits at the plaintiff's residence. From here, InvEnergy tries to devise a plan to shut off turbines around the plaintiff's home during periods that noise exceeds standard limits. Despite the plan, the number of incidences is significant, even in the low wind season like we're having now here in Illinois in July and August. Page 11. InvEnergy's invasion of plaintiff's property rights has caused and continues to cause him economic loss, including the loss of enjoyment of his home and land, disturbance of sleep, headaches, and discomfort, thus the resulting lawsuit. I hope you'll take time to read the entire lawsuit. It's not, for me, it's not written in a lot of legal language. It's a pretty easy read. I think you'll find it interesting, but the point I'd like to make to this board is that you should take action now to avoid letting this happen to more of your constituents. It is your duty and responsibility to protect the rural residents that are forced to live with these machines. It's been unfair to leave the financial burden of recourse for rural families that must live with these machines to something like a lawsuit. Let's sit down and have a conversation about this issue before it harms another family. As the county truly had an ordinance that protected all, those that signed, those that did not, and those that had no say-so at all, then this burden on rural families would not be. Please note we're starting to see a pattern here which is inherent with this industry. You previously have heard from Gary Meyer in Wisconsin, who sent a personal letter to this board and lives with the noise issues in the InvEnergy Forward One complex in Wisconsin. You have heard from Ted and Jessica Harkey, Dave and Jean Miles, Gina Isabelli, who live with the InvEnergy complex in Pilot Township. And now you have heard from Daniel Williams, who lives with the issues from the InvEnergy complex in Oregon. Vermilion County is not Washington, D.C. Please, let's get together and have a legitimate conversation to find a way to help the people in your district that are losing their health and well-being to this issue. Thank you for your time.
Kim Cameron, rural Rankin. Just wanted to, you should have a handout, to all the board members. Here's one for the clerk. It's just a little history, of the, months that, not only here in Illinois, the windiest month, and then the months that we don't have a lot of wind. And so I kind of took it back from the most recent, which actually is deals with the United Kingdom. They also experienced the same similar months of high winds and low winds as we do here in Illinois. And so that is the first article that I wanted to give to you, and I highlighted the wind company actually states that August is generally a low wind month. And so this again is not just something that's unique to Illinois. The second one is from the U.S. Department of Energy. It actually deals with 2008. And again, June, July, August, and September I highlighted for you. And then Mendota Hills and Crescent Ridge, which are two wind farms here in Illinois, and you can see their output, and in those months where it actually drops off quite a bit for production because we have no wind. And then there is, the last page is the average wind speed in Illinois from the Illinois State Water Survey, and that deals from 1991 to 2000. And the graph there shows, again, June, July, August, and September when we have our lowest wind production, wind speed. And so it's to my understanding that InvEnergy has been conducting a sound study here the last couple of months. And I actually have a call into the Illinois State Water Survey to see if they have a even more updated years up, which they're going to be getting back with me, and I'll present that to you next month. So I just wanted to let you all know about what our windy months are and what our not so windy months are. Thank you.
Thank you, Mrs. Cameron. Okay, that concludes our public comment period for this evening. Thank you for those that shared that. This time the chair would recognize Mr. Fox. He has a statement he'd like to make.
Thank you, Mr. Chairman. I want to thank the county clerk for being so precise on the minutes of our last meeting, especially the audience comments. Since I'm diabetic, I have to leave the last meeting before audience comments to check my blood sugar and relieve myself as I've done in the past. That's why I sat in the back row. Understand people's problems about the wind turbines and other problems in our country. I don't know what can be done about the turbines in that part of the county at this time. It's a great honor to be a member of the board for more than 45 years. Thank you, Mr. Chairman.
Thank you, Mr. Fox. Moving on to item 10 on our agenda, report from Committee on Committees. As you know, a vacancy occurred on the county board due to the passing of Mr. Mills. That vacancy has been posted, and a nomination for that filling of that position has been made. So Mr. Mayor, as chairman of the Committee on Committees, Mr. Chairman, would you go ahead with your report?
Thank you, Mr. Chairman. The Committee on Committees did meet, and we vetted the credentials of Mr. A.J. Wright to fill the vacancy, and the Committee on Committees moves for a vote of concurrence for the appointment of Mr. A.J. Wright.
Is there a second on the motion of concurrence? Mr. Griswold, thank you. Any other discussion? All those in favor, please say aye.
Aye.
Those opposed, motion carries. So, Mr. Wright, would you come forward, and, Judge Clary, I believe you're going to do the honors while they're making your way up here. The chairman would like to recognize Judge Clary. Judge Clary is closing out his career as a bench judge here in the Fifth Circuit, and has done a great job, and we're going to miss him, and we'd just like to recognize him at this time. Thank you, Judge.
Thank you, Mr. Chairman. It is an honor for me to be here with you this evening, and I'm happy to carry out this particular bit of business.
Please repeat after me. I, A.J. Wright.
I, A.J. Wright.
Having been appointed to the office of county board member. Having been appointed to the office. Having been appointed to the office. Of county board member. For District 7. On October 8, 2013. In this county. Do solemnly swear. Or affirm. That I will support the Constitution. Of the United States. And the Constitution. Of the State of Illinois. And that I will faithfully discharge. The duties of county board member. For District 7. To the best of my ability.
Mr. Wright, it's traditional that a newly seated board member give a multi-minute speech, but we'll defer to you. If you'd like to make a comment, please take advantage of that. And if not, welcome to the Vermilion County Board.
My Danville Township guys here, they know I can do that at the board meeting. So you might not want to ask me to do that.
Very good. Mr. Wright, I think there's a seat in the back row, 4 in or so, a vacant seat back there. If you'd like to take that seat, that would be fine.
Okay. I just want to thank everybody for coming out, and I appreciate this, and I'm looking forward to serving on the board. Thanks.
Thank you, Mr. Wright. Also, I would ask the chairman of the Committee on Committees for a report on committee assignments. As you know, the Nursing Home Committee is no longer functional, and as a result of that, with the appointment of Mr. Wright, it was time to reorganize committees, and so that committee has met, and they've got a recommendation.
Terry will be passing out the new committee assignments as we iron them out in the Committee on Committees. We moved the number of people on committees from 9 down to 7 to kind of relieve some of the burden on committee members. I know some people were having a hard time with all their assignments, making all the committees. So we moved the number down to 7, 4 for the majority party, 3 for the minority party. And I would be happy to entertain any questions on the list if you want to, if anybody has any, otherwise my report.
Thank you, Mr. Chairman. The Committee on Committee assignments don't require board action. They're simply assigned based on your desires. The various representatives from the Republican and the Democrat Party have met and tried to honor the requests of the board to serve on the committees that they have requested. So this is the product of that assignment. If you have a change or a question, you need to see your respective party leaders, and that can certainly be adjusted on down the road here if necessary. So thank you, Mr. Marin. Item 11 on our agenda tonight is an update from Mr. Mike Blazer. He is an attorney for InvEnergy, and he has agreed to come and address the board and give us an update on what's going on with InvEnergy. Mr. Blazer.
Thank you, Mr. Chairman and members of the board. As the chairman indicated, my name is Mike Blazer. I'm outside counsel for the California Ridge Wind Energy Project and the related company InvEnergy LLC. I was involved in the original process by which this project received its permit from you folks. And I was brought back in on this project toward the end of May to deal with the situation that's arisen and principally with the complaints that have been received from the Hartke and Miles families. So I'd like to first walk you through what's happened since I was brought into the project in May, and then I'll open it up to questions from any members of the board that might want some further information. First of all, just so you know, I answer to upper management. I was brought in to figure out what the problem is and once we figure out what the problem is, to fix it. So the first thing I did was to retain an outside consultant, a highly qualified acoustic engineer, somebody who does this sort of work, to conduct a study to figure out what, number one, whether or not these turbines, and there are two in particular that are the source of the complaints from the Hartke and Miles families. We know them as 57 and 75. Like I said, number one, to find out if those turbines are exceeding the noise limits that are set by the Illinois Pollution Control Board. That's a critical thing for me to find out, because if they are exceeding those limits, we're breaking the law. And that's, again, one of the reasons why I was brought in, to figure that one out. And number two, to find out, regardless of whether or not we're exceeding those noise limits, to find out what the source of these complaints is. So in mid-June, I retained an individual named Michael Hankard, who's got an enormous amount of experience doing this sort of thing, and particularly with wind farms. I hired him, number one, because of his experience, and number two, because he doesn't cater his results to the nature of his client. I wanted an independent expert to tell me the truth about what the problems are. In early July, I began communicating with Bill Donahue. Primarily, he was forwarding questions to me from the Hartke and Miles families. And through Mr. Donahue, we provided to them detailed information on who Mr. Hankard was, what his background was, and very specifically the kind of study that he was going to conduct in, frankly, very technical terms. We also, at the same time, started trying to set up a meeting with the Hartke and Miles families to explain what we were going to do and to get an agreement from them so Hankard could get on their properties to set up his equipment to start doing these measurements. In early July, I apologize for reading from my notes. At my age, it's the only way I can remember all this. In early July, we were told by, and I don't recall whether it was Mr. Hartke or Mr. Miles or both of them, that they were not comfortable with my selection of Mr. Hankard. They were suspicious of it, and they suggested that we hire Dr. Paul Schomer, who I'm very familiar with. I will tell you honestly, as a lawyer, I don't usually, particularly when somebody's threatening a lawsuit, I don't usually hire the person that they've asked me to hire. But in this case, because of what my purpose was and is, and what my directive is from my management, we went ahead and also hired Dr. Schomer. And it turns out that he and Mr. Hankard had worked on a number of projects in the past, and they're very comfortable working together. There was some delay there because Schomer was working out in Colorado on another project, and it took him a couple of weeks to get back and get the ball rolling on this project. Around that same time, mid-July, I was contacted by an attorney named Jim Thompson, not that one, the other one, hired by the Hartkes, and I confirmed with him that we had agreed at his client's request to hire Dr. Schomer. And, I'm not gonna get into what or why we didn't have a meeting, but the bottom line is, the meeting with the Harkey and Miles family never happened. And on July 29, Mr. Thompson confirmed to me that they were not going to allow us access onto their properties to set up the equipment. That caused us some delay. It doesn't make it impossible to conduct the study, but Hankard and Schomer had to reconfigure their equipment and implement what's called a surrogate study. Basically what that means is they set up their equipment on other properties so that they can nevertheless gauge it in relation to the two turbines, so that they can nevertheless gauge what the impact of the noise may be or is on the Harkey and Miles properties. So they have to do substantially more work to do that. At the same time, after telling us they wouldn't give us access to their properties, Mr. Hartke also started criticizing the specifics of the sound study that we were going to conduct. And again, Mr. Donahue forwarded those criticisms to me. I responded back with the responses from Hankard and to some extent Schomer. And one of them, for example, just to give you a sense of what we're trying to accomplish here, Mr. Hankard pointed out that the study that we're conducting is actually not consistent with the study recommended by the Illinois Pollution Control Board. And he's absolutely right. And it's because that portion of the regulation was enacted long before wind turbines came to Illinois. So the Pollution Control Board actually recommends a much lower interval of testing than what we're conducting. We're conducting a lot more testing for a much longer period of time to get accurate results. I should add, sometime after we agreed to retain Dr. Schomer, we were then told that they weren't happy with either Hankard or Schomer and we should hire somebody else. And at that point I stopped and said, we've got Hankard and Schomer and that's what we're going to use. As I said, at the end of July, it was made clear that we weren't going to get access to the two specific sites. I directed Hankard and Schomer to develop the surrogate study, which they did, and the testing program started August 10th. Now, do I know August is a lousy wind month? Of course I do. We all know that. But I needed to get this thing rolling and on the ground. We had already lost a month trying to get access. I needed to get this thing rolling as fast as possible to get any results we possibly could, just to get it going. August was a lousy wind month. We didn't get, I don't want to say good results, we didn't get any results. We didn't get enough results to be specific for Hankard to be able to tell me, Hankard and Schomer, to be able to tell me that they had enough data to specifically define whether or not, number one, we are exceeding the PCB noise standard, and number two, whether we are or not, if there is in fact a problem that is causing the situation at these two homes. Hankard, because he's a scientist, described it as a statistically inadequate sampling. In English, that means he just didn't have enough data because we weren't running at a high enough speed for a long enough period of days. I directed them to keep going because, contrary to what's been suggested or accused, we are not about the business of faking results. We have not entered into a conspiracy with Mother Nature, and my directive is to keep this study going until we know what's going on, no matter how long it takes or how much it costs. And I've been given an unlimited budget by my client to get to that end. We get to September, and the problem for September was, because of a directive from the U.S. Fish and Wildlife Service that dates to before this project was ever built, several of the turbines had to be slowed. It's called curtailment, and it deals with endangered species issues, particularly the Indiana bass. So September was also a lousy month for results. As of yesterday, which is when I asked Hankard and Schomer to give me their latest information on how much verifiable data they have is that over that span of 2 months, they only have 2 3-day periods that are enough to give them even a clue of what's going on, which is nowhere near enough, either for them or for me or for InvEnergy. So I've directed them to keep going. Again, because we're not in a conspiracy with anyone, we're not trying to fudge any data. My mission, again, is to get the data necessary to figure out what's going on here, and we intend to keep this study going until that happens. Schomer specifically talked to me yesterday and said, effectively, October 7th is to him equivalent to August 7th. It's as if nothing happened, because he's just not satisfied with the quantity of data, neither is Hancock. They are hoping with wind picking up, and to some extent, corn coming down, we will get much more realistic results across a much broader spectrum of turbine speeds to finally figure out what's going on. As soon as I know that, as soon as I have a report with the board and the chairman's permission, I intend to come back and let you know what that is. We're not gonna play hide the banana. We're not gonna keep the results from anyone. If the results are that we are causing a problem, we're going to fix it. But I can't know that until I know what the study says. So, that's where we are as of today. I'd be happy to answer any questions any of the board members or Phil or anyone else may have.
Mr. Stark?
Yes, sir.
So the two people have been complaining all this time, you asked for permission to go onto their property to try and solve the problem, and they denied you permission.
They did. I even went further, and, in order to make sure that if something went wrong on their property, if somebody got hurt or something, whenever I do something like this, and it's not just with wind farms, I also deal with a lot of other environmental issues. So I have kind of a standard form access agreement, that we ask the property owner to sign. It allows my people to come onto their property. It also provides that my client will indemnify the property owner in case any damage is done. And I circulated, I gave that through Mr. Donahue. We initially provided that to both the Harkey and Miles families, and then when the other Jim Thompson came on board, and Mr. Harkey's attorney, I also provided it to him as well. And it was after I gave him that draft agreement that he got back to me on, specifically on July 29, and said they weren't gonna let us on their property.
So by not getting on their property, you're never gonna get an accurate reading for that. They're denying it, they brought up the claim, and now they're denying you access to do it, so.
Well, I wanna correct one thing. They've denied us access. It made it more difficult for us. It delayed us, but it's not gonna keep us from getting accurate information, because that's what this surrogate study has been designed. And I have a map here. I can provide later the names of the property owners where the equipment's been set up. I think the Harkey and Miles families know specifically where they are because they've been out there quite a bit. But that will generate the same data. It's just that it cost us about a month before we could get rolling. So we'll get to the same place. It just took longer.
Mr. Alexander? Mr. Blazer, thanks. You mentioned Mr. Johnson representing the Harkeys.
Yes.
He does not represent the Miles.
He does not.
Correct.
He does not.
And then you refer to the fact that they won't let, the experts on the property. Does that mean both the Harkeys and the Miles?
Yes.
So the Miles are not legally represented at this particular time?
They are not.
But Mr. Thompson is basically representing the Harkeys, and you're working through him in that situation as far as passing information back.
Right, and I sent him an email as late as last week. I'm sorry, I sent Mr. Thompson an email as late as last week.
Okay.
Because I'm an attorney, again, Bill Donahue's been forwarding some of the information that or some of the correspondence, thank you, that he's been getting from both the Harkey and Miles families, so I'm fully aware of what both of their positions are. I have not dealt directly with the Miles family because I'd be happy to if they want to talk to me. I can't talk at this point to Mr. Harkey directly because he's represented by counsel. But in terms of Mr. Thompson, as I said, as late as last week, I sent him an email, and I've done that several times now, to let him know, here's what's going on, we still don't have enough data, I'm gonna keep them going until we do. So they're fully aware of what we're doing.
That's fine. I just want to go back to the Miles, though. How are you communicating with them? And how do you know that they will not allow you on the premises? Just curious.
Because It's probably, I don't think, Bill Donahue gets paid for this, but I've been trying to communicate with them through him. So, the original request for access, I sent through Bill, and he kindly agreed to act as sort of a funnel, an intermediary, as it were. I sent the original version of the access agreement through Bill, and the responses came back through Bill to me.
Can I go back and ask about the crops? You mentioned about the corn. Is there some damping effect, or is there some, reason for the corn being removed that might create different readings?
It's because both I and Hank Carter Schomer want to make sure that we have data across all conditions, whether it be low corn or high corn. There won't be a dampening effect, obviously, as you get closer to a turbine because you're so high off the ground. A dampening effect, if it applies at all, frankly, would be several thousand feet away from the turbine. But nevertheless, I want to make sure that we have enough, as much data as possible. We started at a somewhat low corn situation, but as I said, we had lousy data in August and September. We're getting close to that situation again. So I want to make sure, whether it's winter, summer, spring, or fall, whatever those physical conditions may be around these properties, that we have data across the entire spectrum.
Could I continue, Mr. Chairman?
Yeah, I'm here as long as you want.
Yeah, that's fine. I just, want to change the line a little bit. And concerning the surrogate survey, it's set up to mimic basically the same territory that the RTs and Miles properties are.
Correct.
There have been several comments from those in that territory within buildings. In other words, the noise level is different, or the effects are different within buildings. Does the surrogate study include interior readings as well? And it's going to be very difficult, I'm sure, to mimic the interior of those houses.
And that's why, that's physically impossible. So it is, all of the measuring devices, there are stationary measuring devices in several places. Those are all outdoors. And that's, the principal reason for that is because the IPCB noise regs are what are called a property boundary noise regulation. If my property is here and yours is there, and I'm making noise here, at the moment I cross my property boundary with my noise, that's when the regulation kicks in. So they are principally outdoor, not principally, they're entirely outdoor noise limits, both, and they're different for daytime and nighttime. They're also different depending on the type of property. And what the guide we're using, regardless of where the property boundaries are, and I want to make this very clear, farmland, for purposes of these noise regulations, is categorized different ways. Principally, there's an A and a C, to make it easy. C is the cropland itself. There is a much, depending on your perspective, higher or lower limit for cropland because people aren't sleeping in the middle of the corn normally. The limits for the residents, even though it's zoned as ag, the limits for the residents are still an A, it's called an A classification. It's a much higher standard, which means it's a much lower limit. It tolerates less noise, both daytime and nighttime. And that's the standard that we're monitoring for, at the residences, not elsewhere on their properties, to determine what the noise is at the residences.
So there's no regulations about differences between interior and exterior buildings in that situation, and there's no testing done on the interior of the building?
There is generally not. No.
Thanks, Doug. Good clarification. Thank you.
Mr. Knight, did you have a question? Mr. Green?
Yes, if noise pollution non-compliance is determined, what several steps would and could InvEnergy pursue to become compliant, and would InvEnergy pay for the remediation?
Let me answer the second question first. We will do whatever it takes, and of course we'll pay for it, because it's our problem. As to what we might do, it depends on what the nature of the problem is. If it's an issue with periodic noise based on the turning speed of the turbine at particular times of day based on particular wind speeds. Each of those turbines is individually controlled and can be individually managed. So if that's the issue, you know, I mentioned curtailment for purposes of bets.